Hello everyone. Today we'll talk about right to constitutional remedies. Part 3 of the Constitution provides for legal remedies for the protection of these rights against their violation by state or other instructions individual. It entitles the citizens of India to move the Supreme Court or High Court for the enforcement of these rights. The state is forbidden from making any law that may conflict with the fundamental rights. Fundamental rights are the rights that grant individuals equality in every aspect, irrespective of race, color, caste, religion, birthplace, or gender. These rights are mentioned under Article 12 to 35 of the Indian Constitution. They are predefined punishment in case of violation of these rights upon the discretion of the judiciary. What is writ? Writs are written orders issued by the Supreme Court of India to provide constitutional remedies to protect the fundamental rights of citizens from a violation. Facts about writs in India. Article 32 also empowers Parliament to authorize any court to issue these writs. Before 1950, only the High Court of Calcutta, Bombay, and Madras had the power to issue the writs. Article 226 empowers all the High Courts of India to issue the writs. Writs of India are borrowed from English law, where they are known as prerogative writs. What is writ petition? A writ petition is essentially a court petition for extraordinary review, asking a court to intervene in a lower court's decision under the Indian legal system. Jurisdiction to issue prerogative writs is given to the Supreme Court and the High Court of Judicature of all Indian states. Parts of the law relating to writs are outlined in the Constitution of India. There are 5 types of writs in India: habeas corpus, certiorari, prohibition, mandamus, quo warranto. Habeas corpus is a writ that is enforced to protect the fundamental rights to liberty of an individual against unlawful detention. The writ commands a public official to deliver a detained person in front of the court and provide valid reasons for their detention. Certiorari. The writ of certiorari is issued to a lower court directing that the transfer of a case for review, usually to overrule the judgment of the lower court. The Supreme Court issues the writ of certiorari in case the decision passed by the lower court is challenged by the party. Prohibition. Prohibition is a writ issued by the higher court to lower court to enforce inactivity in the jurisdiction. It happens only in case the higher court is of the discretion that the case falls outside the jurisdiction of the lower court. Writ of prohibition can only be issued against the judicial and quasi-judicial authorities. Mandamus. The writ of mandamus is issued to subordinate courts, an official of the government or a corporation or other institution commanding the performance of certain acts or duties. Unlike habeas corpus, mandamus cannot be issued against a private individual. The writ of mandamus can be issued to order the completion of a task, or in other cases it may require an activity to be ceased. Quo warranto. Quo warranto is issued against a person who claims or usurps a public office. Through this writ, the court inquires by what authority the person supports his or her claim. Through this, the court inquires into the legality of a claim of a person to a public office. This right prevents the illegal assumption of a public office by an individual. Okay, guys, that's all for today.